This is a double-barreled session with no break in between. Hope you are fully caffeinated and ready to go. Now I will pass off the microphone to Adriana Russo.
Thank you, Janet. Good morning, everyone. Welcome to this session organized by the Singapore International Arbitration Center on demystifying the scrutiny process. Thank you for joining us. I'm Adriana Usan. I head up SIAC's Americas office in New York, and I will be moderating this panel. But before we begin talking about the SIAC scrutiny process, perhaps a bit of a background about SIAC to those of you who might not be familiar with us. So SIAC, we are one of the leading institutions in the world. We provide case management services to the global business community. We have been ranked by the latest Queen Mary University survey as the #1 institution in Asia Pacific, and we are also ranked as the second most preferred institution in the world. We are headquartered in Singapore, but we also have offices in Seoul, in Shanghai, in Gift City, Gujarat, in Mumbai, and most recently we opened an office at Rockefeller Center in New York. Now, obviously, one of the hallmarks of arbitration is that it's a very flexible process. Parties are able to choose where they want to arbitrate. So arbitrating with SIAC does not mean that parties have to fly all the way to Singapore, hire Singaporean law firms, or appoint Singaporean arbitrators. Parties are, very much at liberty to choose the law that governs their substantive contract. They are free to choose the seat, the place of arbitration, the nationality of their arbitrators. So parties can very well have their arbitrations here in Toronto, can Ontario law apply to their case, appoint Canadian arbitrators as we do at SIAC from time to time, hire Canadian law firms, all while being administered by SIAC in Singapore and New York round the clock under the SIAC rules. To give you a bit of an insight of our global reach, over the last 5 years, we have seen more than 100 parties, and we have been administering cases involving diverse seats and governing laws. So today's panel is Scrutiny or Review of Awards, and we are one of the few institutions in the world that actually review awards. The theme of this year's CanArbWeek is practically speaking, and we will be looking behind the scenes of the scrutiny process. So what does the process look like? What do we as an institution look at when we are reviewing awards? What are the timelines like? What is the extent of our intervention to the extent that we do in the decision-making process of the arbitrator? What are the experiences of the counsel and arbitrators in a case where scrutiny is involved? And ultimately, why is this process so important? So we will try to unpack all of these in an hour. We have a fantastic panel of arbitrators. Joining me today is my Canadian colleague, Kevin Nash. As Registrar of SIAC, Kevin leads the SIAC Secretariat comprising of 23 multinational lawyers and case management officers, and they provide best-in-class case management services. No bias here. Kevin is the best person actually to be on this panel, not only because Who's Who Legal calls him the rock star in arbitration, but because of his unique vantage point and experience in handling awards from all over the world. Kevin oversees the administration of more than 5,000 international arbitration cases at SIAC, and he has reviewed and approved thousands of these awards. Of course, we're also very lucky to have secured real rising stars in Canadian arbitration who bring a wealth of experience, both domestic and in international arbitration. We have Rachel Howie. Rachel is the co-lead for the National Alternative Dispute Resolution and Arbitration Group at Dentons Canada. Rachel is also in the roster of SIAC's list of arbitrators. We also have Alexandra Mitretodis. Alex is a litigation and dispute resolution partner in Fasken's Vancouver office. Sorry, Alex. She works on complex files that often have a multi-jurisdictional or international dimension. Now, our aim here is to make this an informative discussion with practical takeaways to the theme of CanArbWeek's session. So feel free to please join us in the discourse. You can ask questions while we are discussing. Of course, I will reserve time at the end of the session for more questions. Now let's start with first institutional principles. Scrutiny is one of the services that arbitral institutions can provide, but arbitrations, as most of you would know, does not always have to include an arbitral center, and it can be conducted ad hoc. And I wanted to ask Alex this question. With your wealth of experience in handling arbitrations, you might have experience both ad hoc and administered institutions. Can you highlight for us some differences?
I think I should be able to hold this. Okay, hopefully everyone can hear that. So ad hoc arbitrations are quite prominent on the west coast of Canada. I'm not sure how much they're used in Toronto in comparison, but there are some advantages to ad hoc. The procedure can be tailored to meet the specific needs of a case. It can be less expensive because you don't have any administration fees or any filing fees. And it can be more suitable where you have sophisticated parties that will have similar expectations in terms of procedure. It can, however, become essentially confidential litigation. And so you do sometimes see that on the west coast of Canada, where people will sometimes even adopt the rules of court for their arbitration, or the rules of procedure of a certain, of a BC court to use in their arbitration. And then what advantages do they have? It's just picking the decision maker and it being confidential. So what are some of the disadvantages? If you don't have the default rules and you don't have agreement on what the rules should be, it can be very time consuming and expensive to craft the rules and to do that at the time of the dispute when the parties are already not agreeing. You need sophisticated and cooperative parties to do an ad hoc arbitration more so than with an administered arbitration. There can be greater potential for delay and procedural errors when you don't have an administrator overseeing the process. And you rely on the arbitrator to efficiently administer the case and make certain choices that the institution would do otherwise. So you're putting a bit more on the arbitrator there. And it can be very challenging where you have parties from different jurisdictions. And so if there are different expectations as to the procedure, or if it's civil law or common law, ad hoc arbitration becomes increasingly more complicated. It is, however, important to remember that you can incorporate the rules of an institution into an ad hoc arbitration. It just won't be administered. So you can decide we're going to do an ad hoc arbitration, but adopt SIAC's rule or VANAC's rules or the ICC's rules. You just won't get that administration component. And of course, you can also adopt UNCITRAL's arbitration rules. And again, this is something that we see a lot on the west coast of Canada. So what are some of the advantages of institutional arbitration? Well, the institutions are well established and experienced. They have rules that you can incorporate by reference into your arbitration clause or at the time of the dispute. The process is significantly more predictable. The costs are also predictable for the most part. You have better access to experienced and knowledgeable arbitrators on the roster. They have trained staff that can assist with the process, much like you have a court registry where you can call the registrar's office to ask certain questions about procedure and filings. You can do the same with an institution. And it can result in a more easily enforceable award. And we'll talk about that later. Some of the disadvantages would be it can be more expensive. There can be some additional bureaucracy, which could cause some additional delay. And there are time limits that are imposed that can be short, but they can be extended if there's a reasonable reason to extend them.
Thanks, Alex. You mentioned cost is predictable and having a case administered might be a bit expensive. What can you share with us? What is the overall cost of arbitration compared to ad hoc arbitration?
So costs fall in different categories. You have the cost of the arbitrator or arbitrators. You have expert fees if applicable. You have counsel fees, and then you have institutional administrative fees if you're using an institution. But the largest cost in your arbitration, if you've done any cost comparisons before, it's always the cost of counsel. And so the costs of various different institutions varies, but typically they're fixed according to a scale of cost based on the monetary value of the claim. And so you'll have a filing fee based on how much is at issue, And then you'll have regular administrative costs, sometimes quarterly based on that as well. They're going to be the smallest part of what your overall costs are in an arbitration. And often when you're dealing with international cases, they can have a lot of cost at issue. And so the administrative fee is not as large as some of the other costs that your client is already incurring. And so the cost you get from the institution would be that commencement fee or filing fee that's non-refundable, even if it settles. Your administrative fee, which again can be administered sometimes quarterly and will be assessed based on the value of the claim and counterclaim often. And then there will be disbursement fees if the center has incurred any fees dealing with the administration of the arbitration. But those are the categories of costs.
Let's talk about the concept of awards. There are different types of awards. There's final award, partial award, interim or consent award. Some emergency arbitrator orders are considered as awards. And Rachel, I'd like to bring you in to talk to us about the concept of awards in the international arbitration context.
So I think you covered quite a few, Adriana. The concept of awards in an international arbitration context, there are different types. There are interim awards, which are usually enforced until the final award and everything is decided in the matter, although sometimes that term is conflated with partial award. Partial awards, of course, will decide only part of the issues that are in dispute. So if there is something akin to a summary determination or an application of limitations, that might form a partial award. What is seen commonly is a partial award on the merits and then a further award on costs, because of course in that context, the award on the merits doesn't deal with everything, costs are still outstanding. There are also emergency awards. The final award, when it is the final award or the award, resolves all of the issues that are in dispute between the parties over which the tribunal has jurisdiction to resolve. And then of course there is the thorny issue of consent awards, where those might arise between the parties, which may or may not be permitted depending on the rules that you're under. The distinguishing feature for all of these is they are separate from procedural orders. So that's the key distinguishing factor.
Thanks, Rachel. I'll stay with you, Rachel. Let's say you are you've won a hard-fought case and you're holding a 200-page SIAC award where your client has won substantially in all its claims, costs fully awarded. What's next? Do you pick up the phone, you call the counterparty, ask for give your bank details, do you go to the court to enforce? What's the effect of this award?
It probably depends on whether you're winning or losing and what your client wants to do, but ideally it's something that if you're successful you can take and enforce. If you're unsuccessful, it may be something that you wish to challenge in a set-aside procedure at the seat. It might also be something where if you are successful, you also wish to set aside, and this is not uncommon, where, for example, the damages are perhaps far out of the realm of what you thought was reasonable, and it is not uncommon for successful parties to also try and set aside awards.
Now I'd like to turn to Kevin. Could you walk us through the process of how the award is made under the SIAC?
Thanks. Good morning, everyone. I should say that I'm from Calgary, so I'm having trouble with the Oilers' victory last night. I think, in general, I'm supportive, but a bit of a conflict. I also just wanted to touch quickly on the ad hoc versus institutional debate. Adriana, I know when you were in practice, I think that the word was on the street you were involved in a 13-year ad hoc arbitration. I think, in general, all else equal, institutional arbitration tends to be cheaper than ad hoc arbitration. There is a direct relationship between the overall duration of an arbitration and those costs. About 80% of the costs are legal fees, and the institutional fees tend to are 2 or 3%, according to the ICC Commission report on costs. So institutional arbitration is really working at making sure that it's cost effective, and I think we do that by making sure that arbitrations are finishing expeditiously. So the process at SIAC for the rendering of the awards, so because we review all of these awards, the tribunal will close the proceedings, so say you could have a bifurcated proceeding, maybe trifurcated, so you might have jurisdiction, then merits, then costs. The tribunal has to submit the award within 45 days of the close of proceedings. Now that's almost immediately, I think, arousing some suspicion or skepticism in all of you, because of course that old tribunal trick is to delay the closing of proceedings until they're well on the way of drafting the award. So what we have to do institutionally is to make sure that we're prompting tribunals to close the proceedings shortly after the later of the hearing, or say post-hearing subs, is that you then want to get the tribunals to close the proceedings. From a tribunal standpoint, you also want to do this as well for the very obvious reason, if you don't close those proceedings, if you don't ask the parties whether they're satisfied, no more submissions to make, then you may end up getting that 11th hour submission when you're on the way to submitting the draft award to the institution. So just as you and Rachel were covering, we've seen all manner of awards at SIAC, but that is the general process.
Rachel, I'm going to ask you, in your capacity both as an arbitrator and as a counsel, what do you think are the benefits of scrutiny?
So it's an interesting question, and when I was looking to prepare for the question, I thought I'd see what other people have also said on the faculty. And I came across this interesting quote from Jennifer Kirby, and she says that the power that an arbitrator wields when rendering an award is exceptional, and that's because when rendering an award, an arbitrator is making a decision that, one, is not reviewable on its merits, and two, is enforceable around the world. No judge in first instance has that kind of power, which kind of sets the stage for why one might want to look at a scrutiny process. And scrutiny, of course, is just the examination and oversight of what's been drafted in the award. So anyone who's ever drafted a brief or any type of written material knows having a cold review and fresh eyes can be extremely beneficial. And you can use all the tricks in the book when you're sitting there drafting an award. You can read section by section, you can read front to back, cold review after a few days with fresh eyes, do your checks for defined terms, do everything. But sometimes things can still get missed. And so there are innumerable benefits for an arbitrator, just even from a spell check type standpoint to make sure things are consistent. From the party perspective, having that oversight and that additional scrutiny of the award can help on a few fronts. One, can help to make sure that there are no typos and that things are clear. There's no interpolation of contractual provisions or things that might otherwise be problematic. To the clients that are instructing you as counsel, they may have to report up within their company, report up to boards, report up to the public if it's a public company. And knowing that through the scrutiny process, you get an award that in form and format is consistent and addresses and checks certain boxes can also help to give comfort to the arbitration process. It can help those internal clients see what the reasons were, what was discussed, ensure that everything that's in the table of contents is covered, know where to find things in the award. There can be some very large benefits on that side. A few other things stepping outside of minor typos and formatting. You ask what the parties do once they get the award. Well, the first thing you do after you've read it, if there is an error, of course the arbitrator and the tribunal, as a tribunal, remains seized to correct errors. There might be a minor obvious computation error. There might be a minor obvious slip or miss, and that happens. And one would like to think that in all situations, parties and counsel will be reasonable and will be able to exchange their emails on that and get the matter fixed, but that's not always the case. And it could be that that minor error is substantial enough that it causes issues with enforcement. And so again, having that scrutiny process to just try and strip out as much of those possible nits can help on the back end of enforcement as well. So those are the benefits to having a scrutiny process within an institution.
Rachel, as an arbitrator, have you had an experience where your award has been scrutinized and you feel that the scrutiny process has infringed upon your decision-making process?
I haven't, so I can't speak from personal experience with that exact process, but just from generally speaking, I don't think I would object to having a second set of eyes look at it, read the matter pulled. It's someone who hasn't been enmeshed in the to and fro, and if it's been a hotly contested or a lengthy or complex matter on any stretch, either due to length or due to technical issues, just having that fresh set of eyes, make sure that everything reads okay and coherently, I think would be a benefit and quite helpful.
Adriana, if I could step into the moderator role. So when you were in practice, you sat as an arbitrator, you've experienced the scrutiny process. So leaving aside that you now work for SIAC, how did you find the scrutiny process? And this is the lawyer's maxim: never ask a question that you don't know the answer to.
Well, I think, honestly, I felt that was the best part of the job, being able to look at all these drafting all these awards and sitting through and looking at the masterpiece that is in front of you, but also being able to help the parties make sure that the award is enforceable. As a counsel before at SIC, we don't only look at the typos. The numbers, of course, are very important. We see a lot of misses and zeros, and that's a problem if you're winning a huge sum of amount. But we also go into looking at jurisprudence, case laws. We look at the laws, whether they're cited properly. We look at transcripts, whether these are cited properly. And we even look at jumps in reasoning. But we also have to be very, very careful when we raise these points with the arbitrator.
But you as arbitrator,
Oh, I see.
did you find it helpful or irritating?
Extremely helpful. So I was making sure, I tried to make sure that the award was perfect because I knew my colleagues would be looking at it. And a number of them would do so, but then there will be misses, and we've seen that in some of the awards that I've made, and I'm quite thankful for SIC for doing that. So, back at you, Kevin. What is the general process or approach that SIC takes?
So, I mean, effectively the scrutiny process, you're proving a negative. And when Adriana was in the Secretariat, anytime if there's a correction, interpretation, additional award, we look at it a bit as a failure of the scrutiny process, or if there's an award that's set aside or has been refused enforcement. But if you think about it from the Secretariat's standpoint, it's not as easy as just saying that enforcement is going to be in the jurisdiction of the respondent party. So first you're looking at compliance with the seat, but we can't look at all of the procedural requirements in every possible jurisdiction. What we try to do is make sure that this is a substantive review. The tribunal is absolutely at liberty to reject every suggestion that we have. The language of the SIC rules is that, so ultimately the Secretariat and the Registrar has power over form. So if a tribunal said, I don't want to have a dispositive part, I don't want to have an operative part in the award, which I've actually seen before, effectively an award that just ended with an ellipse and just kind of drifted off, so no orders proper, that is something that we would have charge over, anything that goes to the forum. But the language of draw the tribunal's attention to points of substance, we really just want to fortify the tribunal's analysis. So the best relationship that you can have with a tribunal is a back and forth, where the tribunal has considered the suggestion or recommendation from the Secretariat, but has ultimately declined it because they are confident in the way that they've decided. And I can give you an example. I shared this a few times publicly. We had one of the most legendary cases, I think, at SIAC. I will never forget it, those Chinese New Years that were lost. So you had a claimant that had won everything, and maybe the most creative and obstructionist respondent that I had ever seen, to the point that I almost admired the respondent. Challenge after challenge on the basis that the first challenge was so devoid of merit that now the arbitrators were prejudiced against them, so now we have a new challenge because they couldn't take us seriously after the first challenge. And we went, so the claimant had won everything, and within the arbitration clause, the parties had expressly agreed that the losing party is to fully bear the cost of the successful party. So when we ended up getting the cost award, we saw that the tribunal had decided effectively to split the baby and that each side was to bear its own costs. So we went with, and these costs were significant. I think the legal costs were around 10 million for the claimant. And so we went back and forth with the tribunal for all the reasons, the transnational tradition that cost all of the event, that the parties had expressly agreed. And the tribunal, in the end, decided that each side was to bear its own costs. Now, it's a separate point that the counsel for the claimant, I think, called me within 30 seconds of that award being rendered, and that's one of those conversations where you hold the phone away from your ear so that you don't really hear it, but that is scrutiny working at its best, because that was the tribunal's discretion. That's what they wanted to decide. We had drawn their attention to it, but ultimately they decided each side was to bear its own costs. That is scrutiny operating perfectly.
Kevin, you mentioned earlier that additional or correction of awards is like a failure, or feels like a failure. And because of that, we did have an internal competition at the Secretariat who would have the least amount of corrections in their case docket.
That's why you announced that you won?
Yes. Yes, and that, but
I
part
don't
of...
see this on the slides, this entire question and answer.
So part of the parameters is figuring out whether dissenting opinions EA orders, are these counted? Are these awards that we scrutinize and should be counted in terms of, the competition?
Janet and I were having an interesting conversation on minority opinions the other day. So, I mean, a minority opinion is not part of the award. So sometimes you will see, minority opinions are different. Sometimes you'll see a minority opinion that actually makes for a better award, and you look at it and you think, okay, yeah, there was a different view on these issues. And other times you will see minority opinions that are wholly meant to obstruct and affect the enforceability of the award. So we don't scrutinize it in the same way as we would on a merits award, but we also want to make sure that it is consistent with the award, that the dissenting arbitrator has had a chance to look at the award, the timing, and that this is something that is transmitted along with the award that doesn't form part of the award.
The arbitral scrutiny process varies from institution to institution, and I think some of the practice notes from other institutions provides that it takes about 5 to 6 weeks to complete scrutiny process, of course, depending on the complexity of the case. And because of this, I think some of the criticisms that we hear in the market is that the scrutiny process adds to the delay. I know Kevin keeps a live tracking system on timing, everything from commencement, appointment, applications, and for scrutiny. Can you talk to us about the latest number? I checked, it was 12 days. I don't know how many now.
Yeah, so we're around 10 and a half right now for 2024, but of course you have to read that in context. So you would have consent awards that you might be able to do in 2 days, and then you would have maybe a 200-page, really chunky award that is going to take you 19 days, and that's going to end up at 21 days. And I think most things that you do institutionally, it's really about meeting the expectation of the parties, and this is the same for a tribunal. So if you were dealing with, say, a $7 billion major project dispute, I think that the parties would be concerned if the tribunal announced that it was submitting its draft award to SIAC for scrutiny 2 weeks after the hearing. That would be surprising to the parties. So it's really about managing the expectations of the parties, making sure that the timeline is in accordance with how long it's taken. But I think sometimes when a scrutiny has been slower than it should be, we need to make sure that we have something to say. You wouldn't want to be passing back a scrutiny with just some minor typos that you cleaned up. The other, I think, somewhat thorny issue is depending on the story of the case or the claimant and the respondent, if the scrutiny is taking longer and the claimant, for instance, had a really ambitious or speculative case, it might start sort of tipping the hand of where the tribunal is going. And so that's why we want to be pretty consistent on our timing, so we don't want some scrutinies taking half a day and other ones taking 30 days. And that's why we have these live tracking systems, because we really want to be uniform and harmonized in terms of how we're doing things. And we have the staff strength in the Secretariat. It is a matter of some legend, a partial award we had in the many thousands of pages, and we just get more of the lawyers on this. So I might set up a team of 6 lawyers, including me, that are all looking at the award together, so we can make sure to be around and get more to that median time of around 10 or 11 days for the award.
We used to have an internal SIC Award Checklist, and this internal checklist has now been made public. So Kevin, could you walk us through the SIC Award Checklist?
Okay, so I will try to do this very quickly, and I would encourage everyone to look at this. I think, or previously, and I'm sure Rachel, maybe when you're drafting awards, because I look at checklists from other institutions, and I think that it is relevant for any institution. And I know that one of SIC's board members, Pierre Bienvenu, he's actually in Singapore right now. He had a big hand in the drafting of this, as did Adriana and some other members of the Secretariat. So the first section, general items, these are quite obvious. The name of the awards, cross-references, applicable set of rules. You would be surprised, you do get this wrong from time to time, but if you've been running it under the incorrect set of rules, by the time you get to the award stage, probably not much we can do. And sometimes when I'm talking about scrutiny really starts from commencement. There's only so much you can triage once you get to the award stage. Names of the parties, of course, that's important. Tribunal secretary, making sure that they've submitted a signed declaration. One thing that we're starting to be very strong on at SIAC is shadow secretaries. We don't want anyone involved in the case that hasn't run conflicts, hasn't completed a signed declaration. every once in a while you'll see a new name from the law firm of the arbitrator that pops up. That's something that there's very little tolerance for in institutional arbitration. Arbitration agreement, applicable law, jurisdiction. I think some of the issues that you will run into in arbitration is with the non-participating respondent. I often say that the more difficult respondent is the intermittently participating respondent, but to make sure the tribunal has given a short statement of it, or that it's satisfied in the jurisdiction over in the contractual matrix, that's important. Procedural history, I think there's views on this. We heard it in the first panel, the potential for AI in the procedural history. I think because of some due process paranoia, these procedural histories are getting longer and longer, but that's where the institution is there to assist as well, because we have the case record. So often we're beefing up the procedural history, making sure that every important event in the arbitration has been outlined by the tribunal. Going to some of the merits of things. So constitution of the tribunal, any irregularity, you want to make sure that is been canvassed and covered in the award. If you look at item 16, if there's been a previous award in the same arbitration, what you ultimately want to have is you want to make sure that each award can stand on its own. So sometimes the tribunals have to be aware of how they're referencing previous awards. You can see in item 17, item 18, these are some of SIAC's procedural mechanisms, and of course in item 19, setting out the seat of arbitration and the consequent lex arbitri, very important language of the arbitration. All of these things should have been covered in procedural order, but they should again be set out in the award. All the requests for relief and dispositive issues to be decided, and of course, all the requests for relief, but no more than those requests for relief that have been made. You don't want to be going outside the boundaries of the parties' submissions. Looking at some of these substantive items as well, one thing that we often see that is not claimed or dealt with is interest. So you're looking at potentially pre-arbitration interest, post-arbitration interest. Some of this, depending on the seat of arbitration, that's going to apply automatically, but of course the parties typically will need to claim that. You don't want to go outside the boundaries of the submissions. Item 28, we will see from time to time. Every authority that is referenced, you need it to be part of the case record. If something has not been put to the parties, or the parties have not submitted on it, a tribunal should be slow to rely on it. Item 31, we've been talking about consent awards, and the process for consent awards is actually quite interesting. So the tribunal in a consent award will want to put it to the parties, so the parties will have any comments, or maybe you guys will provide the draft consent award that you've agreed with your counterpart, and then that will channel quickly to SIAC for scrutiny, so it might go back to the parties twice, because we'll provide comments on the parties' draft, tribunal looks at it like, yeah, okay, that's fine, put it back to the parties, and then be able to finalize. Costs on item 33 don't really need to cover. And then the dispositive. Sometimes when I'm talking to counsel, I will say that they should just be staring at the dispositive, and this is often what I am doing. You want to make sure the dispositive works. So if you have, for instance, if you haven't indicated the obligation, I've seen dispositive parts where the losing respondent almost has an option to comply or not a time limit, as we'll see in one of the examples coming up. It's not just awards that are set aside or awards that refuse enforcement. It's awards where the dispositive doesn't work. So all the orders and the decisions that the tribunal has dealt with in the body of award should match the dispositive part. And I suppose as a practice point, and practically speaking, of course, for arbitrators, it is always great to get the parties to agree on the list of issues that fall for determination. The much more difficult task is when the parties do not agree on the issues that the tribunal needs to decide, and then the tribunal needs to come to a determination on the issues that fall for consideration, and then once it's dealt with it in the body of the award, then it needs to be reflected in the dispositive as well. And sometimes this will be jurisdiction specific. There's certain jurisdictions, for instance, if you're just to say the respondent is to fully bear and reimburse the claimant's legal costs, there's been some awards that have not been enforced on the basis that they have not crystallized the exact amount of costs. So depending on the jurisdiction, that's going to inform our process as well. And of course, signature, date of the award, item 39. I tend to not like the language of where an award is made. An award is made at the seat of arbitration. So if you were drafting the award in Bangkok and the seat of arbitration is Singapore, the award is not made in Bangkok. I generally find that it's more simple to just indicate the seat of arbitration. Or you could say in a Singapore seated arbitration, this award is made in Singapore, the seat of arbitration on date, and that would work as well. So what we've noticed ultimately with this award checklist, I think that it has given us greater precision on our scrutiny, and I think that the quality of the awards are better that are coming from tribunals as well.
Under the SIC rules, the registrar, Kevin, decides the costs of arbitration at the end of the proceeding, at whatever stage it ends. So poorly drafted awards, what's your take on that? Does that affect the cost of arbitration, the arbitrator's fees?
Yes. We are now informing tribunals at the outset, so we will tax arbitrators' fees for delay. We're certainly looking at the quality of the award. We want to reward efficiency. Arbitrators' fees are on an ad valorem basis, so this is not an hourly. So depending on how the tribunal marshals and shepherds the case, that's going to inform their remuneration. So say if the tribunal's fees were capped at $200,000 and the arbitrator takes 500 hours or 600 hours, we are a little bit constrained. We can pay a fee over and above, but if the tribunal is able to do it more expeditiously, then they got that 200,000 cap. So when I determine arbitrators' fees, as you know from your time in the secretary, in my first instance, I will actually not look at the hours that the arbitrator has taken. Because we scrutinize the award, we have a real idea of the forensics and what's happened in the arbitration. We should not, I think, as arbitration institutions, particularly on the ad valorem system, we should not be overly moved by the hours. Because if the work is the same and it takes one arbitrator 200 hours and then another arbitrator 100 hours for the same amount of work, should the fees be different? So we really sort of lean into the actual work performed, and sometimes arbitrators won't even give their hours. I think that I've seen an arbitrator indicate his time spent by saying a lot. Many thousands of hours, and there wasn't really a point in counting at that stage.
Alex, from the perspective of an external counsel, are there benefits or challenges that you have encountered with your clients as regards scrutiny, the scrutiny process?
So the benefits from counsel and from, I think, the client's perspective is, so the scrutiny of awards is a distinctive feature of SIC and ICC arbitrations. There are other institutions, those who practice any IP arbitration will know WIPO does a scrutiny process as well. Probably not to the same extent because you have smaller amounts of dispute often, but they do actually still do that. And so what scrutiny does is it maximizes the legal effectiveness of the award by identifying any defects, which improves the award's general accuracy, quality, and persuasiveness. The scrutiny of the draft award reduces the scope of errors, and it helps ensure that the awards, at least with respect to their form, are high quality and consistent, which a client is looking for when they're spending a lot of money. It can be a challenge when a client has spent a significant amount of money that they see typos or misspellings or things like that. And so having a scrutiny process reduces the need for an application for corrections to the tribunal. It also requires less lawyer time reviewing and editing the awards to then provide corrections to the tribunal. On top of corrections, of course, parties can also ask the tribunal for interpretation questions on the award. Again, that's minimized when you have a scrutiny process. And so while good arbitrators will take care to ensure their awards are well written, there's no doubt that a review by fresh pair of eyes, as Rachel said, is beneficial. And that's true for clients, from client's perspective or from counsel's perspective. It may be the arbitrator doesn't want someone else looking at their work or editing their work, but from counsel's perspective, I think it's seen as a good thing. This is especially so where it's a sole arbitrator, and maybe there's no tribunal secretary, so there is no second set of eyes. In fact, they may not even have an assistant. So it should be beneficial to the sole arbitrator in particular. If awards regularly contain mistakes or routinely are subject to applications for corrections or interpretation, it can undermine the confidence in the arbitration process that big institutional clients have. It is rare that an award will not benefit from some part of this scrutiny process. And comments on points of substance, things like pointing out that the tribunal may have missed an issue or reached a decision on something not raised by the parties, or may not have sufficient reasons for a particular aspect of the award, that's all going to be very helpful for the enforcement process as well. And as Kevin mentioned, there's often mistakes in math and in calculation errors. And if you're not using AI to help you with your math, it's helpful to have the institution. There can also be issues that are pointed out with respect to contradictions, inconsistencies, and reasonings at time as well. However, I will point out that minor issues as to form can also be addressed through things like the checklist. So if you don't have an institution, arbitrators, of course, can go online and get the checklist as well to help with their review process. So on the other side, what are some of the cons? So really there's two main concerns, and they've slightly been addressed already. One is the timing aspect, and I'll come to that. But the other one is that the institutional scrutiny process can go beyond the mere vetting of an award at certain instances or with certain institutions. So you've appointed this particular arbitrator, this particular tribunal. You may not even have agreed to have a tribunal secretary, and now you have another group of people that are reviewing the award and giving some kind of input into it. And so some clients may not be comfortable with having more people involved in the award process. The other concern is that you could have weeks or months. And Kevin, one thing, maybe when you pick the microphone back up, or you have it there, what happens in the instance of having an award for interim relief that's in an injunction where it's moving very fast and you don't have 12 days, weeks, you need 24 hours for something, let's say? What happens with the scrutiny process there?
So you have to do it within hours. So we've got 2 emergency arbitrations running right now. Absolutely, if there's a call on a bond on Monday morning and you need a preliminary order and the emergency arbitrator submits it to us Sunday night at 2 in the morning, we need to have that out in a few hours. And that is kind of like the implied contract that we have as administering the institution. And there will be other triggers that you will see where an award has to be issued by date, and effectively as lawyers you can't miss a date. So emergency arbitrator orders we typically do certainly in much less than a day, and most often in 3 or 4 hours.
Yeah, well, that's good to hear, because one of the bigger concerns people have and clients have in particular is the timing. If they want an award within 30 days or 60 days, and now you're adding a couple weeks onto the process where you have a complex, lengthy award, that can cause some delay. But as you're hearing from Kevin, at least with SIC, they go out of their way to do it as the client needs or as the file needs. And truly, the real impact on timing is the choice of the arbitrator. If the party selected arbitrator is very busy and has a lot of cases, that's usually what's actually going to cause delay more so than the institution's scrutiny process. The last thing I'll say about pro and cons is where you have a relatively new arbitrator that's less experienced on a case, there's a huge benefit to having a scrutiny process, like the sole arbitrator who has no tribunal secretary and perhaps not even an assistant to do a second read. For the new arbitrator, it's very helpful for both the parties and for the arbitrator.
I'll just add one point there, because that's a great point, Alex. Another area where that might come up, not just with a new arbitrator, but I was tossing around with a colleague the other day, industries and areas where there are very few people who could sit as arbitrator by virtue of the dispute resolution agreement between the parties, or by virtue of the technical nature of the issue. Sometimes you might end up with someone where you can pick one of 3 or 4 people who might have the language and technical industry capabilities and meet the contract provisions. And so in that situation, you might not have a luxury of choosing someone that's the most experienced arbitrator who you would want to choose, and having this backstop in behind them might be highly beneficial. But that kind of goes back more to contract drafting and why you might want to choose one institute over another versus at the award stage, but it relates heavily to that point.
We see that as well, effectively, where parties have overly specific qualifications of the arbitrator. So it will be 20 years frontline hotel desk experience. Has for some reason been included in an arbitration clause. So then you're getting an industry expert, but maybe not an arbitration expert. And then I think institutions that have scrutiny can help that arbitrator along on the procedure.
We have gone through SIAC Award archives and we came up with real life examples to show how scrutiny works. So I'll pass this over to Kevin and ask Alex and Rachel to chime in, comment.
Yeah, please yell out when you've seen this. This first one ends up being a computational error. As we said, we don't become lawyers because we're great at math. There's this very famous test for 12-year-olds in Singapore. What we used to do is we'd send the math questions to the entire secretariat, the 12-year-old math questions. Typically, one or two of us would be able to answer the math questions. That's how hard those are. So often computational errors. This is what it might look like when we, of course, everything that we do is optional for the arbitrators. So you can see that there have been some computational errors there, and then also awarding. I'm looking at this as well. I don't know if you guys feel the same. So it's pre-award interest. So hopefully in the body of the award, the tribunal has provided some grounding for why it's awarding pre-award interest. So post-award interest kind of goes without saying. So computational error.
I just want to jump in on that because when you're dealing with the enforceability of awards, obviously typos are not probably in most instances going to impact the enforceability of your award, but where you do start to have things like Kevin just said, where there may be no groundwork for the pre-judgment interest, that's where you start to run into enforceability issues and where the scrutiny process is helpful.
I would suppose for you all as counsel, and especially if you've been unsuccessful, I think one thing that we're often doing is asking tribunals to fortify their analysis. So say it is a huge decision on the taxation of costs. So the claimant is awarded his legal fees, the tribunal decides 75%, and they pick this 75% out of the air. I think you want to see the rationale. So for a taxation, for the award of costs, you don't want to see a very long award and then all of a sudden effectively just one line without reasoning. So particularly, I guess, when it's against you, you want to see more reasoning. And this could also lead, I think, to, we're starting to see more almost obstructionist requests for corrections or requests for interpretation where you're trying to effectively relitigate something. So that's why you want to make sure the award is tight. So we would not expect anyone in the audience to be reading all of this. So there's a question on the law that applies. Is it Cambodian law? Is it Hong Kong law? So this is the kind of comment for you SIAC arbitrators. I see some of you here. This is the kind of comment that you would get from the Secretariat. And you can see this very careful language. It's always out of an abundance of caution and avoidance of doubt, subject to the tribunal's better discretion. But this is what we see. And then you can see on the right side that the tribunal has taken this comment into consideration and that it is on the law that actually applies. Important. This is something that could threaten the viability of the award, applying the incorrect law. So here we have a final award. Save as the cost, claimant successful. They've allowed the claimant's claims. Respondent shall pay the claimant together with interest at a rate of 5.33% per annum. That's the default judgment rate. And this is the comment that we have. So you're looking at the rate of interest. Sometimes that is not made clear. Also asking the tribunal to provide the provisions under the SIAC rules, and then importantly, reserving its jurisdiction. So say in a final award, all other claims are rejected, so we're closing off everything, but in a partial award, you may want to indicate where the tribunal still has jurisdiction, so if there's going to be a final cost award.
Yeah, these are good examples of where the scrutiny process is helpful because there's legislation in various different jurisdictions, including in various different provinces in Canada, that you can't set aside an award based on an error to form or a technical irregularity. And so clearly these kinds of examples that Kevin's going through are true corrections that are valuable to being made as opposed to just some things related to form or typos.
This next one of the challenging things, especially say for the practice that you have when you guys are counsel under multiple sets of institutional rules, it's almost like institutional arbitration is crying out for some harmony in how institutions deal with the cost of arbitration. So in SIAC, you have the tribunal's fees, SIAC's fees, This is called the cost of arbitration, and this is what you pay deposits towards. And then you have the legal and other costs. That's the party's legal costs and disbursement. So you can see in this order, so reimburse the claimant the sum of $31,000, same being the deposits. So it's from the deposits, it's the actual registrar's determination of costs. So that would result in somewhat of a windfall, so over awarding. So this is the actual cost of arbitration will be from those deposits, also setting up the parties' submissions on interest, and then the legal and other costs, those legal costs and disbursements. And those are the kind of comments that you would see. Respondent paying the claimant's amounts, the tribunal reserving the power to issue a further award dealing with interest. And then you go to SIAC's comments. By the way, this is not unusual how tribunals respond. Fine. That is the tribunal. I think one of the most instructive experiences I had, I think one of my first reviews that I did, I think I had like 250 comments, and the tribunal was on the award, so he just gave 1-word or 2-word answers, and agree, correct, but irrelevant, would take too much time, wrong, disagree. And again, this is the kind of conversation that we wanted. Just trying to move along through these quickly. This is actually quite important what happened here. So you can see the highlighted passages, and then when we go, end up going somewhat of a time lag. Eventually, we're going to get AI to solve this. Okay, there we go. So reserving its jurisdiction, and then indicating whether this is an order or declaratory relief. And then importantly, if there's going to be any time limit by which the amounts will be paid to the respondent. And then you can see in order E, from the original draft, the tribunal has taken in our comment, and it's now to be repaid to the respondent within 15 days, which was important, because otherwise there would have been no impetus to actually pay that amount in a reasonable amount of time.
Well, and just quickly on that one, that's exactly the type of thing that you might genuinely not think about, and just assume that, well, the parties can all agree, we can go back to the tribunal, we can just figure this out. But there are some situations where the opposing party, for whatever reason, it could be legally, it could be because of their employer, it could be because you're acting opposite the state, they genuinely cannot agree. And they could be subject to criminal penalties if they try and agree. So you need to have it clearly spelled out in the award at every stage exactly what's to happen. And it is something that I know, especially at West, we take for granted doing the number of arbitrations that we do. It's a smaller community, but once you expand the scope globally into international disputes, you really need to have that clarity at every stage.
Kevin, how long does it take, or is there a time limit imposed on the tribunal or the arbitrator in coming back to you on the corrections? Because that's where I think from the party perspective, they worry there's delay because first the award goes to the institution, they make the corrections, goes back to the arbitrator, goes back and forth, and then that's where you end up with a month of corrections.
Yeah, and I think that speaks to not having comments for the sake of having comments, because especially in the case of a 3-member tribunal, the tribunal may need to get together to discuss the amendment sometimes, or if the suggestions and recommendations are quite vast, that's going to take some time. So you really want to pick your spots on what is actually important, what is important to the sanctity of award. So it's like, say, on a defined term that has been defined twice in the body of the award, it doesn't really matter. Often I'm trying to pull back the counsel that I might be working with on a scrutiny of saying too much. Let's look at what actually matters. And it's actually some logistical things, the circulation of signature pages. So if you were reviewing an award and you've got a tribunal based in Vancouver, Sydney, and Tokyo, and then all of a sudden we review the award and pass it back, and then all of a sudden everyone realizes, oh, what about the wedding signatures? Are we circulating signature pages? So all of this needs to be done in the context of the scrutiny process, and we've done it so many times. We really have, hopefully, that procedure set out, but it is a good point, because it is going to take some time. And sometimes it might be 2 rounds, 3 rounds, 4 rounds of scrutiny. I think it's usually better if it goes 1 round of comments, the tribunal will give its comments on why it is or isn't accepting the changes, and then back to us, and then we proceed to transmit. I might just do one more, because we want to save some time for questions as well. And I think this speaks to drawing the tribunal's attention to points of substance. And because often the worry and the concern is, and people will ask us, well, will you ever change the tribunal's mind? The tribunal may change its mind because of our comments, but we would never suggest that the tribunal change its mind. So you can see the holding here that the claimant's claim for the release of the retention sum is dismissed. So this is the initial draft that we have received from the tribunal. And then if you look at our comments thereafter, with the standard 3 seconds, of course, this gives me time to organize my thoughts so here are the Secretariat's comments. And then if you look at the eventual result in 420 on the right side, that the tribunal, taking into consideration the Secretariat's comments, holds that the claimant is now entitled to the release of the retention sum in this amount. So the tribunal has reversed its finding. We've given the rationale. We have not suggested that the tribunal change this, but here are the submissions. Here was your finding earlier in the award, and for the tribunal's consideration. And if the tribunal wants to take it in, and I think again, this is Scrutiny working well.
I think we have a few minutes for questions. Yes. Okay. One back.
First, I promise this is not a loaded question. It is academic interest only. No, but really, I'm just wondering, will SIAC administer an arbitration where the parties have opted out from the scrutiny, which I think is found in Rule 32? And if the answer is no, may parties, if they use the UNCITRAL rules and ask SIAC to administer, since those rules obviously don't house this right, are you still going to scrutinize?
Well, that's a great question. So we're similar to ICC in that we consider the scrutiny process a fundamental part of case management at SIC, so parties would not be able to derogate out of the scrutiny process. I've actually never seen it. And then to your question about the UNCITRAL rules, so we do administer under the UNCITRAL rules, and our guidance note, it's effectively the tribunal's option. So if the tribunal wants to have the benefit of the scrutiny, they can, but we don't impose on it. And we will certainly see senior tribunals effectively will be like, yeah, we're good. We don't need new scrutiny. We're going to proceed to transmit this award. That's perfectly fine.
Out of curiosity, how many people in the audience, by a show of hands, have gone through a scrutiny process, either as counsel or arbitrator? Yeah, decent amount. I think we have another question there.
It's Joe Richland. First of all, I'm a big fan of scrutiny. I've been scrutinized a lot. And I've always thought that the work product of my award after the scrutiny is better than the work product before the scrutiny. All ICC, I might add. I was just struck by something Kevin said, and there's one particular concern that I have with scrutiny is that sometimes the Institute requires more than is necessary in terms of the award. And I don't think you intended this, Kevin, but you did suggest that if you have a long award, the arbitrators might get more fees. And I would have thought that the governing rule should be that it takes more time to write a short award, provided it is complete, than to quickly write a long award and overcomplicate things. So my concern is sometimes the tribunals want too much in terms of unnecessary detail on issues that don't matter. And on the other hand, how is the compensation of the tribunal assessed when the tribunal spends a lot of time getting to the nub of the case?
So I hope that I said the opposite, and I think that I did, because
Maybe.
Because we don't look at the hours. So you're looking at efficiency. So a longer award, and in fact, when you see a tribunal that you think is padding and is writing a long awards is, as you would know, can actually be quite dangerous. So if the tribunal is taking a lark through all of the jurisprudence and drafting a 200-page award on a very simple dispute, we are concerned as a secretariat about that because you can make an award more vulnerable. And when you do this enough times, and I've had conversations with tribunals where we will look at language in a 3-member tribunal that we think is a little bit wobbly and not perfect, and then I will have an uncomfortable call with the chair that will say, We know the language is not perfect. That is the price of a unanimous award. This is what we've deliberated and decided, and this is why we're here. So certainly, there's no extra credit for long awards. So that is, and really no extra credit for additional time being taken. We prioritize efficiency. So if an arbitrator can give us a 40-page award and spend just enough time, even on a large fee cap, they are going to be rewarded rather than disincentivized. We don't want arbitrators taking more time than necessary. So sorry if I was unclear.
I'm just curious, if there were multiple theories of liability and the arbitrator decides on one, you expect them to treat everything, and then they say this is dispositive, we don't have to deal with the others?
Well, I mean, you would often see that those don't fall for consideration. I think that there's some sort of clever language that a tribunal could use. Sort of, without knowing the exact circumstances, I think that it is better to deal with those. So this might be an observation from the tribunal, even though it doesn't inform our analysis, because we decided on this theory of liability for good order, and the tribunal observes that the result would have been the same, even if we use these three other theories. I think that it is good to deal with those, because you don't want a tribunal or a party running to court saying that the tribunal didn't deal with this submission. So that's what I've generally seen. I'm trying to remember if it's in one of your awards. I think not.
We reached the end of our presentation. Please join me in thanking the panel in the usual way.